Judgment in the matter of Royal Mail Group Limited versus Jhuti.
Lord Wilson will explain the decision of the court.
When a former employee complains to an employment tribunal under the Employment Rights Act 1996 that she or he has been unfairly dismissed, the first thing which the tribunal has to identify is the reason, or if more than one, the principal reason for the dismissal. The task is usually straightforward, but not in this case. Ms. Jhuti was employed on a trial basis by Royal Mail to work in its marketing department. She quickly came to believe that a colleague was offering terms to customers of the company which ran counter to guidance given by the company's regulator and indeed to the company's own policy. She complained about it to her line manager. She was doing what many of us would describe as whistleblowing. The line manager took exception to her complaint. He persuaded her that it was misconceived and that she should withdraw it. And over the next months, he set about contriving a situation in which the company could dismiss her for inadequately performing her work, about which, in fact, he had no serious concerns. By emails, meetings, and the setting of inappropriate targets, he harassed and intimidated Ms. Jhuti and manufactured a trail of evidence which led the company to appoint another officer, Ms. Vickers, to decide whether she should be dismissed. In conducting her review, Ms. Vickers believed the case which the line manager had constructed against Ms. Jhuti. She never realized that it was a false case which he had created in response to the whistleblowing. She decided that Ms. Jhuti should be dismissed and identified the reason for it to be the inadequate performance of her work. Ms. Jhuti appeals to us against a decision of the Court of Appeal for England and Wales, which felt bound by a previous decision of that court to conclude that the reason for her dismissal was whatever reason the decision maker had identified, namely the inadequate performance of her work. So it held that she had no claim for unfair dismissal by reason of whistleblowing under Section 103A of the 1996 Act. Today, we unanimously allow Ms. Jhuti's appeal. We recognize that when an inanimate company makes a decision, it can be difficult to identify its reason for doing so. Its officers may have different reasons. Which reason does the law then attribute to the company? The fact is, however, that in the present case, there was a real reason for the dismissal and an invented reason for it. No doubt in most cases, the reason for the dismissal will be that given by the decision maker. But if a person in the hierarchy of responsibility above the employee, such as this line manager, has deceived the decision maker by inventing a reason for dismissal which she has adopted, we hold that the deception should not infect identification of the reason for the dismissal under the Act. The reason, the real reason for Ms. Jhuti's dismissal was the reason which animated the line manager, namely her whistleblowing, and in that the company had placed him in the hierarchy of responsibility above Ms. Jhuti, there is no difficulty about attributing his state of mind to the company.